Bail application. So let us see the provisions which are related to the bail and then go to the format. So first of all, as an introduction, we must understand that the term bail is not defined under CRPC. Then what is this bail? Bail is a kind of security which is given by the accused to the court that he will attend the proceedings against the accusations made upon him, and it includes a personal bond and a bail bond. So these are the bail provisions which you have learned under the CRPC, and according to that, bail is a mechanism which is used to ensure that the accused is present before the court whenever it is demanded. And the two authorities that can grant bail are police and the courts. Then what is the basic object of bail? The basic and fundamental object of bail is to ensure the attendance of the accused at the trial before the court. And there are two types of offences when it comes to the bail. There can be bailable offences and non-bailable offences. Section 436 provides for the release on bail of a person accused of a bailable offence. In the case of a bailable offence, it is mandatory in nature and the court or the police have no discretion in this matter. And whenever a person is coming up with a bail application in the case of a bailable offence, it's mandatory that bail is to be provided. And the only discretion available with the police is to release the accused either on a personal bond or with sureties. So that's the only freedom which can be taken by the police or the court, that they can put a condition based on a personal bond or sureties can be demanded along with the bail. And in cases where the accused is unable to provide a bail, the police officer must produce the accused person before the magistrate within 24 hours of arrest as specified under section 57 of CRPC. In cases when bail is not provided, the police officer must be producing the accused before the magistrate. So these are the provisions which are ensuring the article which is envisioned in our constitution. And when the person accused of an offence is produced before a magistrate and he is willing to furnish bail, then the magistrate must release the accused person, and the only discretion available is to release either on personal bond or bond with the sureties. So that is also one provision which is applicable in the case of arrested persons. Magistrates also can demand for a surety or he can be released on bail based on a personal bond. And the magistrate cannot authorize the detention of a person who is willing to furnish bail with or without sureties, even for the purposes of aiding the investigation. So that's also one provision which is related to bail under CRPC. And in the case of non-bailable offences, it's mentioned under section 437 of the code. And this section gives discretionary power to the court. That means other than the High Court or the Court of Session. And according to this provision, the court can release the accused on bail in a non-bailable case. And it lists down the circumstances when bail will not be granted or when bail shall be granted with specific conditions, etc. And there is provisions regarding anticipatory bail also. Under section 438 of the code, anticipatory bail is the bail granted by the court in anticipation of the arrest. And when this bail is granted to a person, it ensures that in case if the person is arrested in the near future, then such person shall be released on this anticipatory bail. It's a bail which is available in advance. When you are apprehending some kind of an arrest by the police authorities, you can in advance go to the court and get a bail. This is called anticipatory bail. And no questions can be raised on the release unless the person executing this bail is arrested, and therefore it totally depends upon the arrest that the order granting such bail becomes operative. So before the arrest, we have to prefer for the anticipatory bail. Then only that term will mean anticipatory. And the applicant filing for the anticipatory bail shall have the reasonable apprehension of getting arrested. So this is the precondition which is to be satisfied before granting the bail. And the arrest of such person shall be in respect of the accusation of him committing non-bailable offence or cognizable offence. So in both the cases, maybe it's a non-bailable offence or a cognizable offence, we can prefer an anticipatory bail, and the courts having competent jurisdiction shall direct that in the event of the arrest, the person shall be released. And conditions on the person seeking the bail. It is the duty of the person to appear or make himself available whenever required by the police officials for the investigation. It's actually for the investigation purposes that the police is withholding the accused in jail. And when a bail is given and when there is a condition that they have to be produced before the police, whenever it is needed for investigation, they have to present themselves before the police. And he must not induce or threat for dissuading him from disclosing facts of the case. And the applicant shall not go outside the territory of India without taking the prior permission of the court. So once the bail is granted, there are certain conditions attached to it. And one of the conditions is that without the prior permission of the court, that person is not able to travel outside India. Or if the following conditions are stated in point 1 or 2 are fulfilled, and if such person is ready to give bail, he should be released from custody. And it is subjected to section 439 CRPC. And that also grants power to the High Court and the courts of session to cancel the bail and put the person into custody. And these are the special provisions or the special powers given to the High Court and the Court of Session. Then bail application. The bail application under section 437 of the Code of Procedure, Criminal Procedure, is filed before the court of the concerned magistrate. And it is filed after the arrest of the accused by the police. And it can be filed by any close relative on behalf of the accused if the bail application is being moved when the accused is not before the court. And it is always signed by the counsel who is filing the bail format either through this memo of appearance or power of attorney. And no court fee is to be paid on the bail format when the accused is in custody. And the details of the FIR, name of the accused, father's name of the accused, it should be properly mentioned in the bail format so that the jail authorities are able to identify him properly after the release order from the court. So this is the format of the bail application. First of all, we have to mention the name of the court. In the Code of the Sessions Judge Ernakulam may be the place name, you can add as you wish. Then criminal miscellaneous petition number dash of 2020. Then you have to mention the crime number under which the proceedings are moving on. Crime number dash of 2020 of the Ernakulam police station. Then mention the name of the applicant, his details. That means the details by which we can correctly identify the applicant. That's what is to be done in this particular line. Then we have to mention petitioner accused. Then State of Kerala represented by Divisional Inspector of Police, Crime Branch, Ernakulam. He is the counter petitioner complainant. Then petition filed on behalf of the accused under section 437 of the Code of Criminal Procedure. And all the facts which are related to that particular case we have to mention here, like it should be mentioned in paragraphs consecutively numbered, just like 1, 2, 3. The petitioner is the accused in crime number dash, then mention the name of the police station and give the details of the case. That the present FIR has been registered on false and bogus facts. The facts stated in the FIR are fabricated, concocted, and without any basis. So these are all the words which you can use when you are filing a bail application. That the police has falsely implicated the applicant and arrested him in the present case. So whatever has happened, we have to mention in paragraphs. That means the facts of the case. Then the applicant is a respectable citizen of the society and is not involved in any criminal case. That the facts stated in the complaint against the applicant are civil disputes and does not constitute any criminal offence at all. So in order to get a bail, you have to give facts which are reasonable. Then that the applicant is not required in any kind of investigation, nor any kind of custodial interrogation is required, nor any recovery is to be made at the instance of the applicant. Then you have to mention like the applicant is having very good antecedents, he belongs to good family and there is no criminal case pending against him like that. That the applicant is a permanent resident and there are no chances of his absconding from the courts of justice. So you have to make it clear that this person has or the accused has not done any crime or not committed any crime and he is a permanent resident of a particular place and he may not abscond or he will not abscond from the courts of justice. That means he will be present before the court of justice whenever it is demanded by the court. That the applicant undertakes to present himself before the police or court as and when directed. So you have to make it clear through your bail application that whenever it is demanded by the court, he is ready to come before the court, and that the applicant undertakes that he will not directly or indirectly make any inducement, threat or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to any police officer. Then we have to make it clear that we will not be making any efforts so that the evidence is not gone, or that the applicant further undertakes not to tamper with the evidence of the witnesses in any manner. Then he shall not leave India without the previous permission of the court, and the applicant is ready and willing to accept any other conditions as may be imposed by the court or the police in connection with the case. So after mentioning all these affairs or undertaking, we have to have the correct prayer also to the court. It's therefore prayed that the court may order for the release of the applicant on bail in the interest of justice, and any other order which the court may deem fit and proper in the facts and circumstances of the case may be also passed in favor of the applicant. Then dated this the dash day of 2019. Then you have to put the signature also. The date and signature is also important when it comes to a bail application. So this is all about the bail application. I hope it is clear to you, and thank you everyone.